Oyez, 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 all persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we are prepared to hear argument in 19-4318, United States v. McCauley. Mr. Amos, whenever you're ready, sir.
Thank you, Your Honor. May it please the court. My name is Christopher Amos, and I'm here on behalf of Logan McCauley. Logan was convicted under 18 U.S.C. 2251 and sentenced to a mandatory 15-year prison sentence because of a single 19-second video.
Well, is that the only count? There are no other counts, are there?
Yes, that's correct, Your Honor. There are no other counts. 2251 makes it illegal to engage in sex for the purpose of making a video. The statute does not read for a purpose, and it does not read for one of 10 different purposes. Yet despite the plain language of this statute, this is how the jury was instructed and what the government argued in closing. This is not the law. This is a rewriting of the statute, and it violated Logan's right to due process and deprived him of the right to a fair trial. The government's argument in response is essentially that there is no real difference between the purpose and a purpose. But that is not the language of the statute. And there is not a single case from any court anywhere holding that the purpose is the same as a purpose, or that the purpose is the same as one of 10 different purposes. Every court that has looked at this issue has begun and ended its analysis by beginning with the plain language of the statute, which reads the purpose. Some courts, including this one, have analyzed the purpose from the point of view essentially of what it doesn't mean. It doesn't mean exclusive purpose. It doesn't mean single-mindedness. But no court, and not this one especially, has ever specifically addressed the purpose language and held that the purpose is the same as a purpose, or that the purpose is the same as one of 10 different purposes. Other circuits, like the Second and the Eighth, have understood the purpose from the point of view of what it does mean. In their view, in this context, it means dominant purpose. And dominant purpose, again, is in no way similar to a purpose or one of 10 different purposes. The dominant purpose standard was first articulated in the Surratt case in the Second Circuit, and then followed in 2019 in Rappinger by the Eighth Circuit. It was assumed to be the proper standard by all parties in United States versus Torres from the D.C. Circuit. And the Eighth Circuit recently reaffirmed this proper standard in United States versus Fortier, decided April 15th, and United States versus Fromel, decided August 21st. This court, in United States versus Thompson, decided on April 6, 2020, found that, quote, significant and motivating purpose informed the jury of the controlling legal principles. And not 3 weeks ago, in United States versus Hewlett, in the Eastern District of Virginia, Judge Ellis instructed the jury in a 2251 case on motivating purpose over the government's specific request that the jury be instructed on a purpose. And the instruction in our case, the government is required to prove the production of a visual depiction was a purpose of engaging in sexually explicit conduct.
So are you seeking here a new trial under an appropriate instruction, or are you saying to us that if you read the statute the way you would have us read it, which is for the purpose, that the evidence is insufficient simply as a Rule 29 matter to convict this individual?
I'm actually saying both, Your Honor. Thank you for the question. I am saying 100% that the Rule 29 should have been granted in this case. If you were to take Mr. Logan McCauley's name and put it in place of Palomino Coronado and substitute video for photo, this case is essentially on all fours. Except Palomino Coronado facts were worse than this case. So I am, in fact, asking this court to find that there was no evidence to support the verdict that Mr. McCauley engaged in the sex for the purpose the dominant purpose, a purpose, no matter what standard the court adopts, for the purposes of videoing that sexual activity. There's no evidence to support that. But as a legal matter, the jury was instructed in this case in a way that rewrote the statute. The statute does not say a purpose. It says the purpose. Lawyers can disagree about what the purpose means, and I'm happy to take questions on that, but the purpose does not mean a purpose. They are different words meaning different things. And so at the very least, Mr. McCauley needs a new trial with the proper instruction. But the reality is there is no evidence to support the conclusion that he engaged in sex for any purpose in order to video it.
There was a single video here. Was this distributed or shopped around or put on social media or in some way was the video distributed to reach a broader audience? Was there any distribution or amplification of this video? What happened to it once it was taken? It was just...
Your Honor, I can tell you, Your Honor, that there was no distribution of the video at all. The government called the witness, their witness to the stand, the detective in this case, who said that there was no evidence it was distributed, shared. There was no evidence it was ever viewed again. There was no evidence that anybody other than the defendant saw the video. There was no evidence that he ever tried to give it to anybody, that he tried to distribute it or otherwise post it anywhere. And when the detectives in the state prosecution that's fully underway came to investigate, Mr. McCauley voluntarily told the detectives about the existence of the video, that they would never have found it. They weren't even looking for it, except he offered it to them because he thought it was something they should know. But he made no effort to distribute it, share it, reproduce it, anything like that.
Okay, maybe I've misunderstood. This is Judge Motz. Maybe I've misunderstood the record. I thought that there was evidence that hours after he filmed the video, he told a friend about it. And a jury could reasonably infer from his quick disclosure of the video that he planned to send it out. Further, before the video, he took a series of photographs of himself and NC in bed, and after the video, took another photograph of himself and NC, in which her naked body is exposed. So when you keep saying there is no evidence, and maybe there isn't conclusive evidence, but I'm not sure that really reflects what's in the record.
Well, I think, Your Honor, it's an excellent question. I think it's important that we keep in mind, at least that I keep in mind, that the intent has to precede the act. It's the intent to photograph or video which has to precede the engagement in the sex. So with respect to that, there's a pause during the time, right? I'm sorry.
During the time when the video is being taken, there is a pause where he talks to her, gets her permission, if you will.
Your Honor,
the record again?
Well, the way that I look at the record, Your Honor, the way that it appears to me is that, and what he told the detectives was that they were in the middle of a sexual act. And in the middle of the sexual act, he just grabbed his phone and said, "Is it okay if I take a photo, or I'm going to take a video? Is that okay?" Turned on his iPhone, took a 19-second video, and turned it off. There was no.
This is with a 7-year-old child, right?
No, Your Honor, that's Palomino Coronado. This is with a 13-year-old. This is a 13-year-old girl who, by all intents and purposes, appears to be older than she is, given her physical structure. I understand that that's not an affirmative defense, but in this case, the record does reflect, Your Honor, that they engaged in sex 4 or 5 times over a 2-day period. That this was maybe the 3rd time they had sex.
And there was a pause where he said, "Can I photograph this?" Right? Is that right?
I don't believe that there was a pause, Your Honor.
There was no pause, but there going forth and he has his camera out. He must be extremely talented fellow.
Well, that's actually what happened. His phone was next to his bed, Your Honor, and they were,
right.
I don't know how graphic to be, but they were in the middle of engaging in sexual intercourse, and he didn't stop what he was doing to go someplace to grab his phone. He was mid-act.
Okay, he was mid, but he hadn't finished act.
But
he asked for permission.
but to your question about whether there was a pause, the only pause was for him to reach for the phone, turn it on, and engage it. There was no...
Well, the jury could construe that as a pause. The jury could very well have construed that as a pause, and we have to take the facts in the light most favorable to the prosecution at this stage. Correct?
That is what you have to take the evidence in the light most favorable to the prosecution. This court does not have to give any deference to the trial court's decision about whether a Rule 29 was appropriate. But I do not believe the record reflects there was any meaningful pause that would give rise to an inference that Mr. McCauley engaged in any kind of reflection about what he was doing. It is somebody who is in the middle of the sex act, who grabs his phone and says, I just kind of grabbed my phone, turned it on, is it okay, took a 19-second video, and stopped. And that's the only time he recorded any portion of their sexual act, even though there were 4 or 5 others of them. To the court's question about
according to his testimony, there was conversation. We were in the middle of sex, and I asked her if we could do the video. Well, I didn't really ask. I just kind of grabbed my phone, and she goes, what are you doing? And he told her he was going to make a video, and she goes, okay.
Yes, Your Honor, and I think that's exactly what happened, and that doesn't indicate reflection to me. There doesn't seem to be a pause, or they stopped to talk about it, or he said, okay, I'm going to position you.
What about the testimony? Excuse me. What about the testimony from the Apple representative that he had to spend time opening the phone and setting it to record in order to make the video?
Your Honor, I think that is exactly on all fours with Palomino, Coronado. What this court, the way I read Palomino, is we cannot...
And I'm happy to, sir, I'm happy to have you give me that answer, but first, doesn't that indicate that a certain amount of time had to take place, a pause, if you will? You can say no, but I think it does. But you now can talk to me about Palomino.
Yes, Your Honor, I'm sorry, Your Honor. Yes, I do not think it indicates the kind of reflection necessary to satisfy the specific intent of the statute. Does it take time to open up the phone, find the camera, turn it on, take the photo? It does. All of that is indicative of the intent to intentionally take the photo, that this was not an accident, that it didn't happen by chance, there wasn't a secret camera. That all goes to what did I do in order to record the sex act. It does not go to, in my opinion, the intention of engaging in the sex act in order to video it. It definitely demonstrates voluntariness and knowingness, but it does not demonstrate, in my opinion, the fact that he intended to have the sexual activity in order to then record it. It is important that I think that he's in the middle of this, Your Honor. He's in the middle of it.
Is it your position that he had to have the intent before they engaged in any sexual conduct? He couldn't form the intent in the midst of it?
I'm going to answer that question 2 ways, Your Honor. One, Palomino uses the word initiated, that the government must show that there's been initiated the sexual activity with the purpose to record it. Can there be circumstances where somebody's motivation changes midstream? Absolutely. But there's no indication that's what happened here. All that we have indication of is his physical, manual working of the phone in order to record a sex act that was already going on. If his intention had changed in the middle, you would see, I would think, evidence of that. Positioning, adopt this, say this to me while we have sex. I'm going to change the angle. I'm going to move the lighting. You would see that he had now transferred from one intent to another. But there's no indication that's what happened. What it would indicate, what the record reveals, is that he was in the middle of it, had a kind of a spur-of-the-moment idea to just grab the phone and take a picture, and he did it, and that's what happened.
One thing, and just trying to make sense of the statute, all of these verbs, employs, uses, persuades, induces, with the intent, it's a specific intent statute, and it has a broad sweep, but the sweep is not, it's not infinite. It doesn't sprawl over everything. And when I look at the verbs and with the intent, it seems to me to indicate that the intention of producing a visual depiction has to form before prior to the initiation of the sexual encounter. In other words, you induce and you entice with the intent, but all of that speaks sort of to the future, and it kind of indicates, I mean, you could read the statute to indicate that the intent has to exist prior to the initiation of a sexual encounter, that it can't form suddenly during a period of, or in the midst of sexual arousal.
Your Honor, that is how I read the statute as well. And when you
Counsel, excuse me. In response to my question, not more than 5 minutes ago, you said exactly the opposite. You said you did not maintain that position, that intent could become an issue in the midst of the sexual act. So are you eschewing that earlier answer? What's going on?
What I'm saying, Your Honor, is that I believe the intent has to form prior to the engagement of the sexual act, prior to the initiation. And what I meant to say to Your Honor, and if I was unclear, I apologize, is that, and it's what we put in our brief, that the intent has to precede the act. Can someone, to Your Honor's question, could you begin with one intent and then transfer to another some point during it? You could. But then you would essentially have two separate sexual acts. You would have one where you went into it with no intention of videoing it. Then you have another separate one where you would say, yes, actually, this part I am going to. So does it have to be...
Excuse me, I don't think that is, and I don't think your answer to Judge Wilkinson was correct, because Judge Wilkinson posed the quite reasonable question that this statute requires that before you initiate any sexual conduct, you have to have this intent. And you said, yes, Your Honor, that's the way I read the statute. But in fact, you are saying that in the midst of sexual conduct, you could change your intent. Or we could have no evidence of intent to violate this statute when the sexual conduct is initiated. But if we have in the midst of it intent to violate this statute, that would satisfy the statutory definition. For example, let us take a hypothetical that is not your case, which is the case of someone who, in the midst, exactly the same facts, but in the midst of the conduct, sets up a big projector and points to it and says, now I'm going to, or points to the big projector that's set up and says, now I'm going to videotape it to distribute. That would be an indication of intent to violate this statute in the midst of the sexual act. Not before it, but in the midst of it. So there's no talk about, no pointing to anything before they initiate the sexual conduct.
Your Honor, if I may, I think that I'm looking at it in a slightly different way than you are. To me, those are two separate events, separated by a moment of reflection and pause, where somebody stops to set up, like in your example, to set up a video camera or a big screen TV so they could record it.
Or take out their cell phone. It takes me about 3 minutes to get the camera working.
Yes, I don't believe
that would be a sufficient pause.
I think there could be evidence, Your Honor, in that sense, but I don't think that I'm being inconsistent. I say that I'm looking at those as two separate acts, the one that you start with and one you pause, and then another one that you begin with. So both of which...
in response, and I will let you, I promise you I'll let you go. So then in response to Judge Wilkinson's question, you're saying that yes, there has to be intent before, but the sexual conduct could have begun before the intent, and then there would be a pause or something that indicated there was intent, and that would satisfy the statute. Correct?
I think that's a fair way of looking at it, Your Honor, that the
Okay,
intent...
thank you.
Yes, Your Honor, thank you. But I think it's important that we talk about the purpose involved in there. It is the purpose. And whether the court is satisfied with the Rule 29 argument, there is no question that Mr. McCauley was given the judge rewrote the statute from the purpose to a purpose, and essentially allowed the jury to convict Mr. McCauley if it considered he had 1% of his intention in engaging in the sexual activity or continuing to engage in the sexual activity was to make a video of it. That's not the statute. The statute doesn't say A. It doesn't say 1 of 10. It doesn't say 1%. It says...
The question I keep pushing is that if the jury were properly instructed, I'm just confused because I'm not sure that the evidence is there to convict on a proper construction of the statute. I have my questions on that particular point. Your client has behaved very badly, and I hold no brief for the kind of conduct that he engaged in. The conduct is surely prosecutable under statutes targeting sexual abuse, sexual assault, child pornography statutes. There are several state and federal laws that would encompass this, and Judge Ellis said, well, this is a case that should be brought in state court, and probably so. And the question I have is, all these other statutes do clearly allow criminal sanctions for what was done here. My only question is, this particular statute, which is broadly written with all of those verbs, but the breadth of it still stops short of being infinite, and I worry about just giving it a very broad and open-ended construction. When I read the statute, I guess what I'm trying to say is, when I read the statute, it seems to me it was aimed at something other than what took place here. That's just the way I look at. That's just the way I look at the text. That this is not what Congress meant. An act, but a single act between two people, in the middle of which it's filmed, but apparently not distributed and even given to the police. Congress can cast a wide net, but I'm not sure looking at this particular statute that Congress aimed. I don't think he entered this relationship or engaged in this sexual act that he had any kind of prior intent to produce visual depictions of sexually explicit conduct. I just wonder whether this is the right statute for this kind of thing. And there are probably 20 other statutes that get at it, but this one I'm not so sure about.
Your Honor, and I would agree with you, and I would say that the only way this fits under the statute is if you change the words of the statute. If you rewrite the purpose to mean a purpose, or 1 of 10, or 1%, the purpose has meaning. Congress chose it deliberately. They could have said A, they could have said N, they could have said any number of things, but they said D. And the only way Mr. McCauley was convicted is because the judge rewrote the statute, changed D to A, and allowed the government to argue 1 in 10, which could be 1%. I agree with you in that way completely. The focus of this case, proposed in this statute is not this kind of behavior. It's not this kind of conduct.
All right. Thank you. You've reserved some time for rebuttal, and let's hear from the government on this.
Thank you, Your Honor.
May it please the court, my name is Alex Barang. I'm an assistant U.S. attorney, and I represent the United States. I also served as one of the trial counsel in this matter. Based on the words and deeds of the defendant before, during, and after the creation of the video at issue in this case, the jury correctly found him guilty of production of child pornography. The government adduced overwhelming evidence of the defendant's specific intent at trial, proving that one of his purposes in having sex with the minor was to create a video of that sexual conduct. The jury, moreover, was properly instructed. To understand the meaning of the statute, we must start, as U.S. v. Bell instructs us, with the plain language of the statute. And absent an ambiguity or clearly expressed legislative intent to the contrary, the statute should be given its plain meaning. Here, the dispute is over the language "for the purpose." Now, Congress did not differentiate among the relative priorities of a defendant's actual purposes. They could have qualified that language. They chose not to. And if Congress wanted to qualify that language, they could have said "but for" or "dominant." The fact of the matter is that the common, ordinary understanding of "for the purpose" means for a purpose. It doesn't mean exclusivity of purpose. Now, the defendant seems to be arguing mainly at this point for a dominant purpose test. But the problem with the dominant purpose test is that it has been rejected by this circuit, albeit in an unpublished decision, Thompson, saying that the theory of the defense instruction requested there, in which they wanted the instruction to be that the government must prove prevailing or most influential purpose, was not a correct statement of law. Thompson is persuasive. The only
your friend there, well, the defendant says Judge Ellis even used a dominant purpose or primary purpose a couple of weeks ago in a different case.
Well, so defense counsel, I regret to say, has misstated the record there. The Hewlett case, which is the defense counsel referred to, was an instruction that the government agreed to. It was not an instruction that was objected to. So I don't think under Masaccio that there should be precedential value in the fact that Judge Ellis adopted the agreed-upon instruction in that case.
Well, why did the government agree to it there?
I was not involved in that case, so I do not know the particulars of that.
Well, was it the United States Attorney's Office that was representing the government?
Yes, Your Honor. It was the same office.
Same judge.
Same judge. That's correct. But like I said, I was not involved in that case, so I don't know why there was a specific agreement by our office to that language.
Well, you know, when the United States comes in front of us, I expect that there is one, they speak with one voice. And so when the United States Attorney's Office in one district tells us something, I expected the same result to be followed by the United States Attorney's Office in another district. When it's the same United States Attorney's Office, I mean, maybe that was just an accommodation, but it seems to me it wouldn't have been too difficult for you to find out what the reason was for this. Well, you knew it was an issue in this case.
I would submit that perhaps one difference is Thompson had been published at this point. And so there was a clearly approved Fourth Circuit instruction in that case, which we did not have the benefit of when we prosecuted Mr. McCauley. That said, our view is that that language that was given in Hewlett and also in Thompson was approved is not all that language is necessary. And the reason for that is that the dominant purpose...
Now, was that language primary purpose or dominant purpose? What was it?
That language was, I believe, a primary purpose, a motivating purpose test.
A motivating purpose.
Correct.
Do you know that, or you know that for sure?
I'm looking at I have a copy of the jury instructions. I'm looking at them right now. It says The jury was instructed, it is sufficient for the government to prove that one of the defendant's motivating purposes engaging in sexual activity with minor girl 1 was to produce a visual depiction.
A motivating purpose. So
Correct.
So your United States Attorney's Office and the judge have changed their position on this case when it was tried to what was given 3 weeks ago or 2 weeks ago in what you call the Hewlett case?
That was in United States Hewlett, that's correct.
Okay. So
So what concerned me here was that this the application of the statute here. It's not the same thing, I realize, but it seemed to me to be sort of getting closer and closer to interpreting this statute as a bit of a statutory rape case, because here the defendant, as I understand it, didn't have any specialized recording or lighting equipment, and he didn't give the minor any instructions, and he didn't conceal the recording activity, and he didn't take numerous photos, and I don't think he ever shared them online. And he volunteered the video to law enforcement the day after the video was made. So I put some emphasis on, or at least I looked at the word producing. I'm wondering if production involves something a little more elaborate or a little bit more sophisticated than what this particular defendant produced. This activity, it's not the same as a statutory rape statute, to be sure, but it seems to be approaching it, and it just seemed that the statute contemplates. First of all, I have the question of whether the statute contemplates prior intent. I think there's a way of reading it that it does, and the word producing seems possibly to contemplate something a little more sophisticated and elaborate than took place here. When I put it all together, I'm just having trouble matching the language of the statute and the purpose of the statute with what happened. But I don't know why, as Judge Ellis suggested, this could not have been prosecuted as a state court sexual assault offense. He suggested it should have come in state court, where the application of the statutes would have been less problematic than this one. This statute has a real purpose, and it serves a very important purpose, and that is people who are sort of in the business of setting up some kind of operation to produce visual depictions of sexual conduct by minors. So there's some kind of operation with some kind of specialized equipment, and I'm just not sure that happened here. It seems so much more. It seems more spontaneous, and I don't know why there's so many non-problematic ways of going at this misconduct. I just don't know why this particular provision was chosen.
I got an idea why it was chosen. Of course, counsel can tell me whether it's right or not. It's easy to prove. It's written sort of as a strict liability statute, and it has a mandatory minimum of 15 years, which this young man received. He's serving a minimum sentence of 15 years right now. Isn't that correct?
Yes, he did receive a 15-year mandatory minimum sentence.
Yeah. So that's the reason that the U.S. Attorney Office would bring it into federal court and prosecute, because of that mandatory minimum. Is that right?
Sometimes when you swing for the fences, you can strike out. It just doesn't bear on the legal issue here, but a mandatory minimum of 15 years for this. This doesn't bear on the statutory language that we're discussing, but it seems harsh.
In this case, to the extent the court's asking about the federal interest in prosecuting Mr. McCauley, as reflected in the pre-sentence investigation report, which Judge Ellis adopted, Mr. McCauley, since he was at least 22 years old, had been engaging in online sex chats with minors. Some of them.
And you all put some of that in evidence, didn't you? I mean, 404B kind of stuff.
We did not put that into evidence because of the court's restriction on the defense getting in mistake of age, and because that was excluded.
Okay. And mistake of age, the judge ruled for you that mistake of age was not a defense.
That's correct.
And she had to be under. The young lady had to be less than 18, correct?
Correct.
But and mistake of age was not permitted as a defense, and you have authority for that. But if she had been 18 or 22, is what she told him. She told him she was 22 and she had 2 children, and she was a stripper. If what he was told was true, or if he'd been able to introduce into evidence and the jury believed it, that he relied on it, there's no crime at all. Isn't that correct?
I disagree with that, Your Honor.
Well, no crime under this statute.
I disagree with that, Your Honor. It's the fact that she is under 18. It doesn't turn on what the defendant's belief is.
Well, no. If she had been 22 years old, it would not be a crime.
Yes, Your Honor.
If she's over 17, it wouldn't be a crime.
Over 18, Your Honor.
Over 17. I thought
right.
I thought if it was 18.
18 or older, yes.
18 or older is no crime. So over
correct.
17, there's no crime. And if she's less than 18, it's a 15 years mandatory minimum.
That's correct, Your Honor.
And you can't use age as a defense.
That's correct, Your Honor. And it goes back to...
It's just like a traffic ticket or something.
No, Your Honor, I would disagree with that, and I would point to the legislative history here. As this circuit has recognized, Congress has enacted a comprehensive regulatory scheme that's designed to prescribe child pornography and designed to prescribe all of it. The concern that the court has had, the Supreme Court has had, and Congress has had, is that child pornography is a permanent record of abuse. And that is really harmful.
I don't disagree with any of that. I don't disagree with any of that. And I don't disagree that there are crimes in the state courts of Virginia and probably West Virginia that are violated, and he might be able to get a real long sentence, maybe a life sentence. I don't know. I'm beginning to get a real long sentence, but this has a mandatory 15 years minimum if she's 17. And it's not a crime at all if she's 18.
That's correct, Your Honor. And the purpose of that is, as the hands-on offender, a defendant like Mr. McCauley has the ability to interact with his victim. He rode in a car with his victim for 3.5 hours, and he could ascertain or ask questions about age if he had any questions. I know defense counsel represented that the victim looked older. I would encourage the court to look at the victim. I would submit that she does not look anywhere near 18, and she looked clearly to be a 13-year-old.
One of the questions I always ask myself is, where do you do the greater damage? Is it in affirming or reversing? And if we reverse here, I don't see that the basic purposes of this statute would be compromised one iota. I think that the production of child pornography that this statute would still cover the mine run of cases and would still cover the vast majority of instances where child pornography is produced. So I don't see that a reversal threatens the compromise of the statutory purpose. On the other hand, an affirmance risks throwing the doors wide open and allowing prosecutors to slam 15-year minimums on a 22-year-old person, or even younger, for behavior which could be construed here as a spur-of-the-moment kind of thing, or relatively innocuous in terms of what the statute is really aimed at. And so I wonder why the greater danger isn't the imposition of 15 years mandatory minimum for people 20 years old. It doesn't sit well with me. And we this statute, as I say, there are ways of interpreting it that give broad effect to the statute, without just completely creating a wide open field. That's the problem. I always say, well, what's going to happen down the road if I vote to reverse here, and what's going to happen down the road if I vote to affirm here? And this, when I balance it off, I think affirmance carries a somewhat greater danger.
Your Honor, if I may address that point, I think reversal here would disregard congressional intent here. Intent was to stamp out all instances of child pornography. And I think there's a fact pattern, an important fact pattern, that a reversal would prohibit prosecution of. And that fact pattern is this. Congress is very much concerned, as was the Supreme Court in Ferber, about child pornography being used to blackmail victims. And so if you have a fact pattern in which someone is abusing a child repeatedly, and they find an opportunity, a spur-of-the-moment opportunity.
Where's the blackmail here? I mean, this is the problem. I mean, you can't just envision circumstances that are far afield from what here. This comes down to the facts here. There's no blackmail.
Well, the problem, Your Honor, is that child pornography, why it's an issue with it being a permanent record, is that the victim knows it exists. It silences the victim. They don't reveal their abuse. And so if a perpetrator, you're asking, Your Honor, about your concern about if you were to affirm or reverse the consequences of that, I'm submitting to you that a consequence of reversing here would inhibit the government's ability to prosecute someone who creates child pornography in order to continue perpetrating more child sex abuse. And that is very much in the ambit of the statute. Congress, in the Senate report in 1996, specifically called that harm out as one of the reasons it wanted to eliminate all instances of child pornography.
You've got one law after another. If there's any area of law that has multiple statutes with a great number of very severe criminal sanctions, it's child pornography. We see a lot of these cases, and they're really bad actors, and the statutes come down on them and come down on them hard, and that's as it should be, because it's an odious activity, perfectly odious. But the question you always have is whether you just, when you have something like this, when society has a legitimate abhorrence of a particular offense, the question you have to ask yourself is, do we just sweep, why? Do we just sweep everybody under that view of social abhorrence to the point where we take a statute and have it cover almost anything? And so you have to ask yourself, there is a danger where you deal with abhorrent activity to just bend the rules and go after anybody, and people get swept up in this kind of thing far out of proportion to any kind of misconduct that they've committed. And the reason they get swept up in it is because of a general abhorrence of the crime rather than the particular circumstances that attended this particular proceeding. And this person is, what he did was not good. It was horrible. It's criminal. It can be criminalized. But I just think sometimes when you get things that are the subject of social abhorrence, you do have to be just a little bit careful in that not everybody gets swept up.
Counsel, maybe you can describe to us the trial and the evidence that was presented that you think supports the conviction here?
Judge Motz, I would like to, but I believe my time is now expired.
I think that you can answer the question. We spent a lot of time questioning.
Thank you. So in terms of the evidence, we believe that the evidence, even under a significant or motivating purpose, which again we disagree is the standard, but even under that standard, we believe we presented overwhelming evidence of that. And there are three buckets you can put the evidence into. One is what occurred before, one is what occurred during, what occurred after. So before, there was the evidence of the defendant online, communicating in online chats with others, seeking out sexual images for these people to create sexual images for him, which is similar to the decision out of I believe it was the First Circuit, in which it was a husband and wife had produced sexual images before, and the jury was told that, or the jury properly read that prior creation of sexual images with the defendant's wife into his intent in having sex and creating a video with a minor. You also have the images that were taken immediately before and after the sex video, in this case, was created, which we submit is evidences the defendant's intent to create a series of images. He wanted to document both the before and the after so that he could memorialize the entirety of the sexual experience. And then, of course, you have what happened during the sexual act, in which, by the defendant's own admission, he said that he was in the middle of sex and then asked the minor if he could do the video, and then he backtracked and said maybe he didn't ask her, but he grabbed his phone and she asked, "What are you doing?" And then he told her what he was doing. And then finally, you have the discussion online about the sex video after the fact, in which the defendant bragged about creating the sex video. And then lastly, going back to in the middle of the sex act, the video itself is very important because it shows panning. It shows videography. So this is very different than Palomino Coronado that dealt with one undeleted still image. This is a video in which the defendant starts with the head, chest of the victim, and then pans down and focuses on his penis penetrating the minor's vagina for about 5 seconds, and then he pans back up. And so our position is putting all those facts together, in addition to the fact that Your Honor mentioned about the time it would have taken to open the phone and use it, show that he certainly had as one of his significant or motivating purposes to create this video.
Well, the conduct that was the basis for the count, and that was enumerated in the indictment as the factual basis for the count was the 19-second video, the iPhone 19-second video, correct?
That is the child pornography charge in this case. That's correct.
Yeah, that's what we're focused on. I mean, there may be, as Judge King pointed out, there may be all kinds of 404B evidence and the like, but what the indictment, the factual recitation in the indictment and the basis for the conviction and the basis for the count was the 19-second video.
Correct, Your Honor. That's the only child pornography at issue in this case.
That's what I thought.
And all this other evidence was, all these other things that you pointed to just now were introduced to prove what that 19-second video was, right?
That's right, Your Honor. So, as was pointed out...
What the intent was?
I'm sorry, Your Honor.
Sorry, go ahead. Go ahead. What the intent
Thank you.
was?
I was going to say, as was pointed out Palomino Coronado, to understand intent, we have to get inside the defendant's head, and often that's going to be circumstantial evidence. In this case, we do have a little bit of direct evidence with the defendant's own statement, but the rest of the evidence I just described is the circumstantial evidence that should be properly considered and construed in the government's favor to find that he did have the requisite purpose to have sex with the minor.
And you take the position that the facts here are distinguishable from those in Palomino.
Very much so, yes, Your Honor.
And why is that exactly?
Well, to start with, in Palomino Coronado, what was at issue was a single still image that had been deleted. And so just the very nature of the child pornography is distinguishable, in which we're dealing with a video. And in the video, you can see, you get a sense of what the videographer here, the defendant's intent was.
But it was a 19-second video. It was a 19-second video that was never published or distributed.
That's correct, Your Honor, but there's no requirement for publishing or distribution. As has been recognized, Congress can properly regulate even locally produced child pornography for which there is no intention of ever distributing it. Again, because the concern is...
Well, you have to ask, what producing here, but in terms of Palomino versus Coronado, I hope you're not suggesting that we can draw a dispositive difference from that precedent, depending on whether the brief depiction was a film or a photograph, because the statute says transmitting a live visual depiction. And I'm not sure that language allows you to distinguish between a film and a photograph. I thought Palomino Coronado is a very powerful precedent here, and I don't think it's that easily distinguished, to be quite honest with you.
And on that point, maybe you can continue trying to distinguish them, because I think that's a fair comparison, at least for us. And that is circuit precedent on it. And if it's not distinguishable, then we are going to have to reverse. So we have, as you pointed out, the first distinction, which may or may not make it legally distinguishable. Are there other distinctions between this case and our prior precedent?
Yes, there are. But before I address those, may I address the live visual depiction comment that Judge Wilkinson made? We didn't charge under that prong in the statute, so that prong of the statute is not at issue here. But turning back to Palomino Coronado and how our facts are different. So we mentioned already how it was a video versus an image. It's also true in this case we had a statement from the defendant, which did not exist in the Palomino Coronado. We also have the defendant bragging online after video was created, another fact that didn't exist in Palomino Coronado. You also have the photos that were taken both before and after, immediately before and after the sex video was taken. And again, I don't think the argument was made in Palomino Coronado, but we are making the argument here that those sex pictures, both before and after, are very much like Morales de Jesus, the First Circuit decision I mentioned previously, in which the defendant's taping of his sexual activity with his wife could lead a reasonable jury to believe that he also engaged in sexual activity.
You may fasten upon those, what you think are those distinguishing characteristics, but to me, they kind of pale before the similarity, but with this case in Palomino Coronado, because both our precedent and this case involve the same basic point of being a single, brief, single visual depiction. And it seemed to me we were saying in that case that we can't extend that statute that far to a brief, single visual depiction. And so, yeah, you can point to some things that you think are different, but it seems to me that they pale behind the underlying similarity. In both cases involve a very brief visual depiction, which wasn't produced with elaborate equipment and which wasn't disseminated, and those similarities seem to me to overshadow the differences to which you pointed. And maybe it shouldn't influence me, but it does. The fact that there's a 15-year minimum sentence for this kind of thing, that's rough.
Counsel, I think that Judge Wilkinson has very well set out the one side. I want to be sure that I have everything that you say suggests the other side. And you don't have to repeat anything you said. I just want to be sure I have in front of me everything you rely on distinguishing this from our earlier precedent.
Yes, Your Honor. I would like to make 3 points in that sense. The first is looking at Palomino Coronado itself and the language from that statute. This court said in that case, to be sure, the situation might well present itself where only one photograph was taken, but where there was other evidence of purpose. And we do not hold that a sufficiency challenge would necessarily fail in that instance. And so I would submit to the court that is this case. It is a one video, granted, but there is other evidence of purpose. Secondly,
here you had to get into all that because, as I recall, as a matter of fact, and I think Judge Motz and I maybe were on that case. Judge Gregory wrote the opinion, I think.
That's correct.
It was a guilty plea case. This was a trial. How's that? That was a guilty plea, and this is a trial.
Your Honor, I believe it's incorrect. I'm looking at page 130 of the decision, and it says the jury found Palomino Coronado guilty.
Okay, all right. I wasn't right on that. That's fine.
So tell me your second point and third point quickly. We're taking a long time here.
Yeah, so the second point is that Congress's intent here was a broad ban on the production of child pornography. That's from Ortiz-Grallo. So applying the statute to defend this case fits within congressional intent. And the last point I would like to make, just to respond to Judge Wilkinson's concern about the mandatory minimum, I would note that Judge Ellis did say that he thought the mandatory minimum was appropriate, regardless of the statute in this case. So I don't think he would agree that the mandatory minimum was an inappropriate result.
And was this on reliance in stuff in the pretrial report?
Correct. It is from the pretrial report where we detailed, and the court accepted, 4 different instances in which the defendant was chatting with children who were 12, 14, and 16 including the 16-year-old, which was immediately proceeding from January 2016 to November 2017, immediately preceding the video in this case, in which he asked this 16-year-old, who identified herself as 16 years old, if she was a virgin, told her he was horny, had a 9-inch sausage, and he wanted to video chat with her and wanted her to provide pics. He wanted to make love to her, etc. The fact that this defendant went from online chats to then driving 3.5 hours to West Virginia to pick up the victim in this case and then brought her back, had sex with her for the purpose of creating a video is a significant federal interest and, in our view, merits the prosecution and the ultimate sentence that was imposed.
Thank you. You've answered my question.
Judge King, do you have any questions? Any further questions?
Sir. I'm fine.
All right.
Thank you.
Let's hear from the appellant by way of rebuttal.
Yes, Your Honor. Thank you. May it please the court. I would like to circle back initially, just talk about the progression of Mr. McCauley's case to the Hewlett case. In that case, the government argued for that a purpose was the appropriate standard. This court said in Thompson that significant or motivating is the appropriate purpose. The government then agreed that that was the appropriate standard in Hewlett 3 weeks ago, and the jury was instructed, and that's not how Mr. McCauley was instructed. The government has agreed on this, that motivating is at the very least how the jury should be instructed as it relates to the purpose. Our position is the
So, counsel, I think that's a really good point. What have the other circuits said?
The other circuits have taken two approaches, Your Honor. Some of them have defined purpose by what it is. It isn't the sole purpose. It isn't the exclusive purpose. They've never really said what it is. They just kind of tell you what it's not. The Second Circuit and the Eighth Circuit have said dominant purpose. And they have said dominant purpose because they decided that, and I think correctly, that Congress's intent was to punish the kind of behavior that encourages the abuse in the first instance. That's the federal interest. Is criminalizing, punishing that behavior which encourages the abuse. That's why the statute is written with the purpose, and Your Honors are correct. 15 years is a long time with no affirmative defense as relates to age. It is a serious, draconian statute that requires a serious, intense purpose. Let
me go back to that dominant. Let me ask you a question about that. You say two circuits say a dominant purpose.
Yes, sir.
In front of that, do they have the word "the" or the word "a"?
Well, I can tell you, Your Honor, that the most recent decision from the Eighth Circuit, this was the instruction that they read. And I'll just read the purpose part of it. And it says, rather, the government is required to prove that one of the defendant's dominant purposes was to produce a visual depiction of such conduct. So they use the phrase, one of the defendant's dominant purposes.
And they acknowledge there can be more than one purpose.
They acknowledge that it doesn't have to be the sole or exclusive purpose, but they tell you that it has to be the dominant purpose, which is, in my humble opinion, significant or motivating, which this court sanctioned in Thompson, is not that different than motivating, than dominant. I'm not sure I could really parse out the difference between significant or motivating and dominant. I mean, that is, what you're saying is it has to be something more than A. Like, that's not what they wrote. Like, this is, as I said, a serious punishment, a serious statute.
You're not contending that it has to be the exclusive purpose.
I'm not, Your Honor, but I'm not that has to be the exclusive purpose, but it has to be.
But it has to be certainly something more than a purpose. It has to be something more than a multitude or 3 or 4 or whatever.
The government said 1 in 10, which could be 1%. Just 1 in 10 doesn't assume all the purposes are weighted equally. It could be 1%. That's what the government.
So where do you get this from the statutory language?
The statutory language as it relates to purpose, Your Honor, is that your question?
Yeah. How does it tell us that what you think the purpose requirement should be?
Your Honor, I think we start with the plain language of the statute, and the plain language says B. It says B. And to Judge Wilkinson, I think that maybe this is a good way to answer the question. If I go house shopping with my wife, and we look at 10 houses, and I say after it's all over, honey, the 5th house is the house for us. And she looks at me and says, yes, that is definitely a house. I say, no, this is the house for us. And she says, that is one of 10 houses that we have looked at today. We are not saying the same thing. We are not saying the same thing. Now, when I say the house, do I mean this is the house to the exclusion of all other known houses in the universe? Maybe. But what I am definitely saying is that the house this is the dominant house of the ones that we've looked at. This is the significant house we've looked at. This is the house that's going to motivate me to go to the bank, get a mortgage, and buy it. That's what B means. At the very minimum, that's what B means. And that's way less serious than a 15-year mandatory minimum.
Well, one of the things that interests me is that we might think we're just quibbling over the definite or the indefinite article with the V and A. And, if that's all it was, then you could, do Henderson versus Kibbe and say that, that minor instructional errors shouldn't be dispositive. But here the difference between V and A is, I think, bears on the whole intention of Congress in this statute, because when you say the purpose, that indicates a seriousness of conduct with respect to child pornography that a purpose doesn't. And when you say the purpose, what it's saying is we want this statute to ensnare serious offenders. And we don't want to put A, because if we say a purpose, we'd be sweeping in all kinds of other people who may not be serious. This is what we're after with the purpose are serious offenders. It's more than just a quibble over the definite and indefinite article. The purpose elevates the purpose of the statute to more serious offenses.
Okay, can I ask you what was the instruction that the government agreed to most recently?
Your Honor, yes. If you can give me 2 seconds, I will pull that.
Just the language
yes,
about purpose.
What he said was motivating purpose, Your Honor. So what the court instructed in that case was that there was an argument back and forth about what it should be, and it said it needs to be a motivating purpose. It didn't say significant, but
a motivating purpose or the motivating purpose.
It has to be a motivating purpose. Which is reflective of this court's holding in Thompson.
And that was in a case in the same district, the same judge,
and
a different prosecutor, but the same U.S. Attorney's office.
The same U.S. Attorney that Mr. Barang was not part of the Hewlett case, but the other prosecutor, Ms. Bills, was the same prosecutor in Mr. McCauley's case and in Mr. Hewlett's case. So while Mr. Barang wasn't coincidental to both cases, the same attorney for the U.S. Attorney's Office was the attorney for both of those cases. And
I thought Mr. Barang tried this case.
Mr. Barang and Ms. Bills tried Mr. McCauley's case. Ms. Bills and Nate Smith, as I'm looking at the pleadings.
Okay, there was a common prosecutor.
So there was a common prosecutor.
Let me ask. I got a question. Another question for you before you sit down. The government says that Palomino is distinguishable, materially distinguishable, correct?
That's what the government says, yes.
That's what the government says. I said
yes,
that's right. Exactly, he said that. But you then have to say Palomino is controlling precedent. Is that right?
That's correct. I believe that this is a sufficiency evidence. This is a sufficiency of the evidence case in much the way that Palomino is. And to Judge Motz's earlier question about was there a pause, I do believe there has to be intent beforehand. There could be a pause to indicate a separate sexual act, but there was no pause in this case. So
okay, but if you could directly answer the question, since we're spending a long time on this case. And so the question that Judge King put to you is that you regard the Palomino case as circuit precedent, right?
Yes, Your Honor, I do.
And maybe Judge King has another question.
You rely on that.
Yeah, and I did rely on that, Your Honor, yes.
All right. That's
And
what I thought.
just
Yes,
sir.
Say that.
I'm Tom. Yes, sir. I'm sorry if I was unclear about that. Can I? I'm running out of time, but I would.
I wanted to say, because it seemed to me Judge King's question warrants an answer, not just of course you believe it's controlling precedent, but just tell us why you believe it's controlling precedent.
Because I believe that Palomino Coronado establishes that it's a specific intent crime, that you cannot conflate the voluntary nature of taking the video with the intent necessary to engage in the sexual activity. The facts in Palomino are virtually identical to this case. Logan made no statement regarding his purpose for engaging in sexual activity. He gave no instructions. He didn't actively conceal the videotaping. There's no purposeful conduct surrounding the use of specific photograph or video equipment. He did nothing to say that indicated it was planned or staged. He engaged in repeated sexual activity and took only one video fragment. And the two had already initiated their activity when he made the spontaneous decision to kind of grab his phone and record the 19-second video clip. Those facts are on all fours with Palomino.
Well, I would have thought those facts you would say would distinguish this from Palomino, but if you say it's on all fours, fine.
Those are the facts, as I'm reading the opinion, those are the facts from Palomino, that he didn't demonstrate it. He had no specialized equipment. He didn't discuss it ahead of time.
But you said the two cases are on all fours. Then I would think we would come out the way you don't want us to come out if they really were on all fours. But that's fine. I think I understand your position. Don't worry about it.
Maybe I misspoke. They reversed for sufficiency of evidence. I think there's a lack of evidence here. But even if we can't get to the Rule 29, Logan is the only one who got an instruction on a purpose. It's the only way the government was able to get a conviction. The judge instructed them one way. They came back with a question on engagement. He instructed them on a purpose, and then Mr. Salvedo and I didn't even leave the courtroom before the jury came back with a guilty verdict. Two final points I want to make. The government said, Mr. McCauley had enough time to ride in the car to realize that she was under 13. Mr. McCauley suffers from traumatic brain injury. He is in the 0.01% intellectually of people his age. He may be, 22 years old chronologically. He is nowhere near that in actual reality. And if the government is allowed, if the court goes along with the government and says, finds what the government wants to, this is what's coming. A mentally challenged 18-year-old high school student is going to fall in love with someone who's 17, who lies to him and says she's 18 as well. They're going to have sex because that's what teenagers sometimes do. In the middle of one of their sex acts, this guy's going to record like 10 seconds of it because 1% of him says, you know what, I'd like to look at this afterwards. 99% of him says, no, that's not what I want to do. But there's 1%, and that 1% gets him a 15-year mandatory. That's what flows from this decision. And 18 and 17 may sound extreme, but from talking to the federal public defender in Newport or Norfolk, I can't remember, they're prosecuting a 19-year-old who had sex with a 16-year-old. It's not that far away. This is not what the statute was designed to do. The purpose means the purpose because it reflects the seriousness of dealing with people whose job and profession or motivation is creation of child pornography. It is not aimed at the mentally deficient 22-year-old who takes a 19-second video with his iPhone. That is not what this statute says. If Congress wanted it to be that way, it would have said a purpose. It would have said any purpose. The purpose may not mean exclusive, but it definitely means dominant. It has to be the motivating, significant, dominant motive for your engaging in the sexual activity in the front end. That's what Thompson says. That's what the government agreed to at Hewlett. That's what the Eighth Circuit and the Second Circuit say. Everybody who has established a standard says that's the standard. And that's what this court should adopt. We ask this court to reverse the conviction completely, factually, under any standard. Mr. McCauley is not guilty of intentionally engaging in sex to then record it, but at the very minimum, this case needs to be remanded for a retrial with a proper instruction. Mr. McCauley, as I said, is the only one who has not received the benefit of that instruction.
Judge Motz, do you have any further questions?
I do not. Thank you.
Judge King, do you have further questions?
No, sir. Thank you.
All right. We will we'll take a brief recess and then
Thank you.
commence our next case.
Thank
you,
you.
Your Honor.
We'll take a brief break before hearing the next case. Judges, I'll call you right back.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, we're prepared to hear argument in 194596, United States versus Collins. And Ms. Morgan, you can proceed whenever you're ready.
Thank you, Your Honor. May it please the Court, Mr. Hamner. I'm Sean Morgan of Steptoe & Johnson, PLLC in Bridgeport, West Virginia, and I'm honored to represent the appellant Ronald Collins here today. Mr. Collins' appeal raises significant questions of constitutional magnitude regarding his rights under the Second Amendment. He challenges his convictions from the Southern District of West Virginia on the basis that those rights were violated by the government. His argument falls into four categories. First, he challenges the sufficiency of count 2 of the indictment due to the failure of the government to allege that he knew of his prohibited status as required by Rahafe versus United States, and he seeks the vacation of count 2 due to this failure. Alternatively, Mr. Collins argues that the district court erred in rejecting his as-applied and Heller challenges that were raised to the indictment, and that these warrant reversal of his convictions. Third, he charges that even presuming that the indictment was valid, his convictions should be reversed due to Rahafe-related errors at trial. First, that the government failed to prove beyond a reasonable doubt his knowledge of his prohibited status as required by Rahafe, and second, that the district court erroneously precluded him from offering a defense pursuant to Rahafe, that is, that he did not know of his prohibited status and therefore lacked the requisite mens rea. He likewise challenges jury instructions that were given and not given regarding the Rahafe standard. And finally, even presuming that there were not constitutional errors requiring that count 2 be vacated, or constitutional errors requiring that this indictment be dismissed, or that there were trial errors warranting reversal of his convictions. He argues that the sentences that were imposed upon him were procedurally and substantively unreasonable, and that resentencing would be required. From a factual standpoint, this case is a unique one that calls into question his rights under the Second Amendment. His charges in the Southern District of West Virginia alleged that he made a materially false statement in connection with his application to purchase a firearm from a federal firearms licensee, and that he was a prohibited person, not authorized to possess a firearm because of his status as someone who had been committed to a mental institution. However, it's Mr. Collins' position that he is not a prohibited person under 922G4, that he did not make a materially false statement regarding his prohibited status when applying for the purchase of that firearm, and that...
Doesn't the jury verdict preclude that particular challenge? The jury verdict on count 1.
We would argue that it does not, Your Honor, because of the underpinning related to his Second Amendment challenges to the indictment. With respect to that...
When did you object to the indictment?
There was not an objection. I did not represent him at trial. I do acknowledge the government's position that the objection to the indictment was not raised below. So, therefore, it would be a plain error analysis for this court under Alano with respect to his first argument. And
isn't that sort of an ultimate no-no not to raise an objection to the indictment until appeal? You're supposed to raise it pre-trial, but this wasn't even raised post-verdict. We're just up here on appeal.
That's correct, Your Honor. And I raised the error when I recognized it when I was appointed on appeal, but I do acknowledge that under Alano that this court can take notice of it only if finding that the error was obvious under the law at the time of review.
How can it be plain error if the indictment tracked the language of the statute?
Well, because the indictment was returned pre-Rahafe, and Rahafe requires that the government prove that Mr. Collins knew of his prohibited status. And I think even the government would concede that it now charges indictments including that Rahafe language, and that was not something that occurred in this case.
Well, all your Rahafe arguments are plain error arguments, right?
Yes, ma'am.
Okay.
Yes, ma'am. With respect to the constitutional challenges under Heller, if the court were to presume that there was not plain error, that it would recognize in dismissing count 2 outright for the failure to allege the Rahafe element as required. I think the most significant issue facing the court today relates to the district court's rejection of Mr. Collins as applied and Heller challenges to the indictment.
I'm a little bit confused on the Heller point, because Heller indicated that that those who had been committed and those who were mentally ill, that there was not going to be an extension of Second Amendment rights to such persons, and that was obviously necessary to get the deciding fifth vote in Heller, because without those, there's been a lot written on this, without those reservations, it's doubtful they would have been able to assemble a majority, and Heller says that mental illness and the rest are outside the scope of the Second Amendment, and the legislature could still prohibit such persons who are presumptively dangerous from possessing firearms. So I'm just not sure that Heller tore that kind of a hole in the ability of legislatures to proscribe the possession of firearms for people who are as dangerous. And this is a classic case of somebody who's dangerous. As Judge Irene Berger found, I mean, she didn't upwardly depart for no reason at all. She had a very thorough hearing. She's very familiar with it, and it seems to me that it falls within the scope of what Congress could regulate. And in fact, there are precedent of this circuit that has upheld the constitutionality of Section 922G4. We've said that that's constitutional, and Heller said that that's constitutional, so I don't understand the Second Amendment argument.
Well, the Second Amendment argument beyond Heller relates to the application of 922G4 as to Mr. Collins in light of the circumstances of his commitment, which I would argue differentiate the circumstances of his classification as someone who's been committed to a mental institution.
Put that in, I think Judge Berger had the same view of this, that a lot of what you're trying to do is to collaterally attack, in this case, the West Virginia commitment order. And there are an awful lot of cases in the Supreme Court which said you don't go about attacking a state court order collaterally in this fashion. And much of the evidence you wanted to put on was introduced for the purpose of undermining the West Virginia commitment order. And there are forums that you can do that in, mainly West Virginia forum, but this isn't the proper venue for rehashing the commitment order, is it?
I don't see it as rehashing, Your Honor. I see it as challenging whether the commitment order is a valid predicate to be able to charge Mr. Collins under 922G4. It has always been Mr. Collins' position that he challenged the commitment order at the time that he was ordered to be temporarily committed, and that he was actually returned to state court to address not only the underlying prosecution but also the habeas petition he had filed challenging his commitment, and that at the conclusion of that hearing, the district court entered an order. He was not deemed to be involuntarily committed any further. The criminal charges against him were not pursued. And the salient fact that I think distinguishes Mr. Collins' circumstance from that in McCroby and in the Midget case that's cited by the government, that is this court's precedent, there was a specific finding by the state court that the habeas and the criminal prosecution would be dismissed.
The problem is we're not in a commitment proceeding. And a lot of the evidence that you were introduced and that you complained that the district court rejected, it made me think, well, wait a minute, we're not in West Virginia court, and we're not in a commitment proceeding.
Yes, and that's Mr. Collins' point exactly, that there was not a commitment order, there was not a sufficient commitment order for him to be barred under 922G4, that when he came back to state court having challenged his commitment, the whole matter was dismissed with a finding that it was being dismissed in a way that, quote, promotes the interests of justice and protects the rights of the defendant. And he was never advised that he was prohibited or that he should not possess firearms. The state did not only did they not alert him of that, they did not tell Nix about that.
Excuse me, he's charged with knowledge of the law.
Well, we would argue that under Rahafe, he's charged, the government is charged with proving that he knew not only that he had been committed, but that commitment meant that he could not lawfully possess firearms.
Oh, I don't think. I think it's that he's charged that he needs to know his status. He does not need to know that his status is violative of the law. It's an old axiom that ignorance of the law is no excuse. The government has to prove knowledge of his status. It does not have to prove that he knew that his status violated the law against this kind of a possession of firearms.
Counsel, are you familiar with our recent Rafe cases?
Yes,
Gary?
Your Honor. Yes. In fact, I cited to Gary in the government's reply brief on page 7.
Well, if you are going to make a Rafe argument, maybe you should be talking about them, because we regard, and are you familiar with Medley?
I am not familiar with that one, Your Honor. But I'm also familiar with the Second Circuit's decision in Bald, which is a 2019 post-Rahafe case that says that...
Well, Medley is a 2020 case.
Oh, Medley. I'm sorry. I did not hear you properly. Yes, Medley. I am aware of Medley. Yes. I misheard you. Even with respect to Gary, Your Honor,
Gary... about Medley, because I think it's the closest to this case.
I'm sorry, I didn't hear you.
I think Medley is the closest circuit precedent to this case, and if you want us to find a Rafe error now, you have to square it with Medley.
Well, from Mr. Collins' perspective, there is plain error because under Rahafe, he is entitled to present a defense as to his knowledge of his prohibiting status. That is his position with
And that means
respect to this appeal.
Ms. Morgan, this is Judge King. He was committed by the Raleigh County Circuit Court to the Sharp Hospital?
He was temporarily placed there, yes, to be restored to competency.
He was there for 3 or 4 months?
Yes, sir.
Okay. And that's in that form that he signed and said he had never been committed, he answered no.
Correct.
And the question was on that count 1 whether he knew he'd been committed for mental reasons to that hospital, basically.
Yes.
And he lied on the form. And that's a crime against the United States, correct?
I understand that is the jury verdict.
And that's not a Heller issue.
I understand that the jury verdict in that regard is binding. His position has been...
Counsel, doesn't that then indicate that he did have knowledge of the offense?
No.
And so undermine his, the jury found he did, but he lied.
But the jury did not hear the evidence that he intended to present under Rahafe, which was that he did not lie because it was his understanding of his commitment that it was not a preclusive commitment under 922G4.
Wait a minute. You have a circumstance here. In addition, the count 1 has a mens rea of knowingly making a false statement, and he knowingly made a false statement in the jury's view about his prior commitment. And the obvious import of the jury's verdict was that he knew about his prior commitment, and he outright lied about it. And so it's hard for you to make a Rahafe argument or any kind of argument, frankly, given the fact that there were 2 counts in this case, and count 1 speaks directly to the question of knowledge of status.
My response to that, Your Honor, is that his defense has been from the outset of the case that when he marked that box, he believed that he was not prohibited and that he was not making a materially false statement. And he
but the jury found against him on that.
But the jury did not hear...
Look at his... Sorry?
But the jury did not hear the evidence that he intended to offer but was precluded from offering, which was that he did not believe he had been committed to a mental institution in such a fashion that it precluded his lawful possession of firearms, and that therefore his statement on its form was untrue.
He had a squabble with his federal public defender down in southern West Virginia, and that's how you ended up in the case. That you had to take it over, and I admire you for this. But is this agreement with the public defender have anything to do with his wanting to run his own case rather than listen to his lawyer?
No, I believe his public defender wanted to be able to make these arguments below and presented them and preserved them for the record, but the district court's rulings were that despite Rahafe, he would not be permitted to offer a defense about his understanding of the import of his temporary commitment and the state court's subsequent order dismissing the state prosecution and his habeas, indicating that his rights were being protected thereby.
And this is all on plain error review, is that right?
Yes, Your Honor, it is.
Mm-hmm. Okay.
Your Honor, I had asked for my time to be broken 15 and 5, and I see I'm over that. So I believe at this time it's appropriate for me to allow Mr. Hamer.
You've reserved some time for rebuttal, and we'd be happy to hear from you on rebuttal. And in the meantime, let's hear from the government on this.
Thank you, Your Honor. May it please the court, Ms. Morgan. My name is Alex Hamner, and I'm representing the United States in this matter. I was originally going to address the Heller arguments. However, I believe that's been pushed aside for the moment. I'm going to jump right into the Rahafe and Medley arguments in this case. I believe that Medley is the most relevant precedent on this matter right now, and quite frankly, I think that Collins' case is distinguishable from Medley for a few reasons. First, unlike Medley, the indictment here did put him on notice that he would have to defend against whether he knew he had been committed to a mental institution. As this court is aware.
On another count, to be sure.
To be sure, Your Honor, yes.
Yeah, okay.
While we did track the statutory language on the 922G4 charge, Medley effectively has determined that that is insufficient. Regardless, the other count, count one, does effectively put the defendant on notice of the fact that he was going to have to defend against his knowledge of his prohibited, not his prohibited status, but his status as somebody who's been committed to a mental institution. So I do believe it's distinguishable from Medley in that regard. Additionally, unlike Medley, the jury instructions here similarly gave the jury the opportunity to determine that he knew of his status as being somebody who had been committed to a mental institution. So the evidence that was presented at trial was directly on this issue in regards to the 18 U.S.C. 922A6 charge. The jury was presented with the evidence that he had actually been committed to a mental institution for 8 months, that he had stood in court and was ordered by the judge to be committed to a mental institution. While he was in that mental institution, after he had been released from that mental institution, he filed a lawsuit about that commitment, wherein he tried to sue Sharp Mental Hospital for forcing him to take medication.
Did he represent himself in that one?
He did, Your Honor.
That's what I was thinking. I had something. I got something wrong there. I was questioning Ms. Morgan. He was first represented by the public defender, Mr. Bungard, and that's the one that he assaulted and beat up, right?
Yes, Your Honor.
And then he was represented at the trial by Mr. Campbell.
Yes, Your Honor.
And then so Ms. Morgan is his third lawyer.
Yes, Your Honor. She came in at the appellate level.
I commend her for taking the case on. He's obviously a difficult situation. But Mr. Campbell tried the case.
Yes, Your Honor, that's correct.
And you tried the case against Mr. Campbell?
I was second chair on the case, yes, Your Honor.
Okay.
Go ahead. Thank you, Your Honor. His lawsuit against...
Can I ask you a question to help me out here? So after Medley, what do we do when we talk about, do we use Alano or not?
I believe that Medley did use Alano and referred to it several times. I recognize that the dissent in that case, Judge Quattlebaum disagreed somewhat with, that was the purpose of his dissent, with his disagreement with Alano.
I think that the holding in Milano is that notice, lack of notice equals prejudice, right? And that wouldn't be the same kind of analysis that you'd have in Milano. To be sure, the majority cited Milano, and I just wondered what we're to do going forward. So do you think that, give me your views on that.
Well, Your Honor, in this case, I do think Alano still applies. I do think even after Medley, I think that Alano is still relevant precedent that the Supreme Court has set forward, and until they change that, I believe that it's still...
The Alano didn't make exceptions for certain type of claims, did it? It didn't say, well, plain error doesn't apply, and this, and this. It may apply if there's an absence of counsel or something, but my understanding of Alano was that the plain error standard was one that was going to apply across the board. Is that your understanding?
That is, Your Honor, and I did not see any language in Alano that limited it to anything less than that.
But Medley, the holding in Medley seems to be in some tension with that, as the majority acknowledged, right?
Yes.
So, assuming that Medley is now circuit precedent, whatever you or Judge Levinson or I or Judge King think about the plain error standard, do you still prevail?
Yes, Your Honor. Because even with the Medley standard being as it is, our case here is distinctive, is rather distinctive, as I've already outlined somewhat, and as I would continue to outline. Medley.
Well, here you have count one, which with a mens rea of knowingly, and so the presence of count one, which speaks to prior commitment, and the fact that a knowingly false statement was made about something he knew about was a prior commitment. Count one establishes definitively that he knew of his prior commitment and lied about it.
Correct, Your Honor. And as a result, I believe that Medley set out several ways in which the government could still have prevailed, and we fall into those categories. Specifically, that the jury was still instructed on these issues, as the court's pointing out, and that the evidence that was presented in this case overwhelmingly proved that he knew of his status as being somebody who had been committed to a mental institution, as evidenced by the jury's verdict. But also this court, if it were to review it, would find similarly because of the evidence that was presented to the trial, or at trial.
Also,
yes, Your Honor.
I know it's maybe difficult to hear. You've got all the evidence that you point to that he knew of his commitment, and that had to be introduced with respect to count one. But what I think conclusively helps you, even more so than the mountain of evidence that he knew of his committed status, is the fact that the jury bought your argument, and the jury verdict, in as clear a fashion as is possible, indicated he knew of his prior commitment and he just lied about it on the ATE form. That's an unusual circumstance. It's not present in a whole lot of things. You don't get that kind of conclusive result. It's not just the evidence. It's the jury's verdict.
Yes, Your Honor. I completely agree, and I think that's, again, largely what distinguishes this from Medley. In Medley, he had been charged with several other indictments. He had been found not guilty on all of those. Several other counts. He had been found not guilty on those, and he had only been found guilty on the 922G1 count. Here, we have two separate counts on which he was found guilty of both, and the missing element that's established in Rahafe and supported by Medley of his knowledge of his status as somebody who's been committed to a mental institution was conclusively found by the jury in its conviction on count one, that he knew of, that when he filled out the form for the ATF form to purchase a firearm, he knew that he had been committed, and that he knew that it was a false statement that he was putting on there, that he had not been committed.
You know, there are a lot of different Supreme Court precedents, and Rahafe is certainly one of them, but Heller is another important precedent, and the one thing that Heller makes clear is that you can still have firearms regulation of somebody who has been committed to a mental institution, and so there's an ultimate danger here of taking something that Heller says can be regulated, and overturning the jury's verdict in such a fashion that it permits a set of very dangerous individuals to carry lethal firearms, and that is what is at stake in count two, and you have to sort of look at these two in pari materia, and this is, as Judge Berger found, and she detailed it, this is a very dangerous person. The statements that he's made indicate an imbalance of a serious sort. His actions, assaulting his own attorney, indicate a serious inability to control destructive impulses. And you put firearms in possession, you put a person like that in possession of firearms, you're asking for another tragic incident. And I think Judge Berger recognized the danger there and looked at the criminal history, and she looked at the total lack of remorse for the things that he had done. She looked at the threats to harm and to kill others, and in my personal view, I think she did an excellent job with this case, and I think that it is exactly what count 2 and count 1 taken in conjunction. It's exactly what should have been done, and I just can't believe this. The West Virginia court found that he was psychotic and committed him, and part of this proceeding is trying to attack that commitment order collaterally. And I don't, I think that states deserve more respect than that.
I'm sorry, go ahead.
Go ahead. What were you going to say?
I wholeheartedly agree, and I believe that the attempt to attack this case under Heller is inappropriate, specifically because the Heller court determined that these types of restrictions are presumptively lawful and permissible. And so to say otherwise, I find it difficult to believe that there's anybody who wants to put firearms in the hands of the mentally ill or the deranged, because those are specifically the types of people that lead to mass shootings and are statistically more likely to attack and harm other individuals. And it's just inconsistent logically to try to arm them when they've been specifically precluded from that historically, even going back to when the ratification of the Second Amendment as outlined in my brief. But furthermore, in regards to this commitment that he received to a mental institution, I believe that Midget is directly on point on this issue. While I recognize that there are different ways to have somebody committed to a mental institution, the definition the definition that's outlined by the ATF, as the code does not specifically have one, falls within, or this type of commitment falls within that definition. But again, referring back to Midget, Midget was almost directly on point in that Midget was examined by a competent mental health practitioner. He was represented by counsel at that time. Factual findings were made by a judge who heard evidence. A conclusion was reached by the judge that Midget suffered from mental illness to such a degree that he was in need of inpatient hospital care. A judicial order was issued committing Midget to a mental institution, and he was actually confined there. And each one of those very points that the court made in Midget apply here with Mr. Collins. He was examined by a forensic psychiatrist. He was represented by counsel. Factual findings were made by a preponderance of the evidence by a judge who heard the evidence. The circuit court concluded that that Collins suffered from mental illness to such a degree that he was in need of inpatient hospital care, and a judicial order was issued committing him to a mental institution, and then he was actually confined there for a period of 8 months. So to say that that doesn't qualify as being committed to a mental institution under 922G4 is inconsistent with this court's precedent and inconsistent with the plain language and plain reading of the statute. And again, as this court has pointed out so far, the time for Mr. Collins to have attacked that would have been prior to his attempt to purchase a firearm. Lewis v. United States specifically outlines that the time to challenge any collateral issues is before is well before trying to obtain a firearm. Mr. Collins could have attempted to restore his right to possess a firearm through any of the programs that West Virginia offers, such as the NICS Improvement Amendment Act that was passed by Congress in 2008, and the West Virginia Code Section 61-7A-5, which provides that the process by which an individual can regain his right to possess firearms due to mental health disability. So he did nothing in an effort to try to attempt a firearm or to restore his rights to possess a firearm prior to filling out the form. And even his assertion that he didn't know he was prohibited is inconsistent with the form itself, because it specifically has a large warning across the top, and again, this was presented to the jury, that says that the questions on this form are going to help determine whether you are prohibited from possessing a firearm. And on that same page, down a few lines, it specifically asks if you have been determined by a court to be a mental defective or if you've been committed to a mental institution. And he said no. So it's difficult to argue, and again, I appreciate Ms. Morgan's taking this case and the difficulty she's had with it as a result of it, but it's difficult to argue that he did not know that he had been committed to a mental institution. And even if we were to extend Rahafe, which the government does not concede for a moment that we should, that he should have known he was actually prohibited. He did know that he was prohibited, and the evidence is, quite frankly, overwhelming in that regard.
Judge Mott,
you say overwhelming and it's uncontradicted too, isn't it?
It is uncontradicted, and again, that's something that's different from Medley. I believe the court in Medley determined that the defendant may not have contradicted, or he stipulated to the fact that he was a prohibited person because he didn't know that he should have contested it. That's not the case here. The defendant, Mr. Collins, knew that he needed to defend against the fact that he had been committed to a mental institution, aware of that because of count one, and he did not contest that whatsoever. In fact, when he took the stand, he admitted to it. So there has been no evidence to negate his knowledge of his commitment to an institution, and it was overwhelming that he knew of it.
All right, thank you, counsel. I think your time has expired, and unless my colleagues have some questions for you, I would like to hear the rebuttal argument.
Thank you, Your Honor.
All right. Ms. Morgan, would you like to offer some comments in rebuttal?
I would, Your Honor. I appreciate the opportunity to do so. With respect to Medley, I do not view Medley as distinguishable from the circumstances involving Mr. Collins with respect to the defendant's knowledge. If Mr. Collins had been afforded the opportunity at trial to offer the defense which he intended, it would have been a defense to count one and count two, that his statement on the form that he had not been committed to a mental institution and his testimony that he did not believe he was a prohibited person would arise from the circumstances underpinning his temporary commitment to Sharp Hospital and the fact that when he was returned to state court,
how do you deal with the fact that the defendant on the stand admitted he knew his status?
He knew that he had been committed, but his testimony would have been that he did not believe that that temporary commitment was a prohibitor under 922G4 or a prohibitor for applying to obtain a firearm, which he was able to do.
All right, but that goes to, that's an ignorance of the law question.
I understand the court's position there, but he would argue that in light of Rahafe, that Rahafe...
no, I mean, Rahafe doesn't challenge that point. Rahafe cuts against you in that sense because it requires only knowledge of status. It does not require that additionally that the individual knew that that status violated the law. And, you know, he's up on the stand saying, of course I knew I've been committed. You know, that's perfectly consistent with Rahafe, and I think that we've been over all of this pretty carefully, but I just want to say that I don't see that Rahafe sort of carved out an exception to the time-honored rule that ignorance of the law is no excuse. All it did is spoke to knowledge of status. Those are very different things.
I understand the court's position, and it was Mr. Collins' position on appeal that that issue is an unresolved issue of law in the Fourth Circuit, and that Rahafe stood for more than what I hear you saying that it stands for, and that he should have been able to present a defense in that regard. If I may correct one other, it's a very minor error, but I'm really cognizant of wanting to make sure that the record is accurate. There were some questions by Judge King earlier regarding representation by Mr. Collins' prior counsel, and the fact that I would be his third lawyer. I'm actually the second lawyer on appeal, so I'm actually the fourth lawyer. I don't think that affects at all the outcome of the case, but I just wanted to make sure that the record was accurate and that I was bringing forth that additional fact for the court's consideration.
Well, what it does do is what both of my colleagues have alluded to, and that is that you've acted very admirably in taking this case on, and I think we respect that a great deal. And as Judge King indicated, it was a very difficult situation with very difficult circumstances, and I think we all appreciate your stepping forward, because it's a service to us as well as to your client that you've done so.
Thank you. I appreciate that very much.
I totally agree with that, but before you sit down, can you just tell me one more time what your client thinks he was entitled to rather than the notice that he was convicted? What was it that he thinks doesn't fulfill the requirements of rape?
He thinks that in addition to being given notice, that he should have been given the opportunity to mount the defense that he did not have the requisite knowledge. And we've been over his testimony, what his testimony would have been in that regard. But he would have intended to argue not only that he was entitled to notice of the government's obligation to introduce evidence of his knowledge, but also the opportunity to rebut that. And his errors are that he wanted to be able to rebut that and was foreclosed from doing so because of the court's holding that it was an improper collateral attack on the underlying state proceedings.
He wanted to rebut it by doing what? Because we have a jury finding.
Well, his arguments, he began to raise these Rahafe-related arguments prior to the trial. And he wanted to argue, and his counsel proffered to the court, that he should be permitted to take the stand and argue that he was not a prohibited person under 922G4 and that he did not believe that he was, and therefore lacked the requisite knowledge of his prohibiting status.
Except when he took the stand, as I understand it, he admitted he knew that he had been committed.
Right. He admitted the fact of the commitment, but he maintained at that time and continues to maintain, and if he was part of this call, he would vehemently continue to maintain that despite the fact that he was temporarily committed for a competency determination, that he was never informed and never has been informed that that temporary commitment precluded his lawful possession of firearms, and that he therefore should not have been charged under 922G4, and that there was nothing for him to collaterally attack because he believed that he was not committed to a mental institution in a fashion that would preclude him from lawfully possessing firearms under federal law.
Well, you run into midget at some point, and that's a problem for you. But
Yes, but I asked her to spell it out because I was not understanding what his argument was. So I
yeah,
appreciate that and join you, both of you, in thanking counsel for her fine argument on behalf of, in this difficult case.
absolutely.
Thank you very much, Ms. Morgan. Appreciate it.
Thank you all very much.
All right. I'll ask the courtroom deputy to adjourn court and get back in touch with us for a conference promptly. Okay.
Very good.
Thank you, Your Honor.
Thank you, Your Honor.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.